What happened to the common law? It's August 8th, 2026. Welcome to yes2hellwith.com. In our last discussion, we asked a fundamental question. What created the office of sheriff? Did the office arise from statute, from the Constitution, or from a much older legal tradition? Today we continue that journey by examining another historical question. What happened to the common law? Before America declared its independence, before the Constitution was written, before modern administrative agencies existed, the common law formed much of the legal tradition inherited by the American colonies. The framers knew it. They practiced it. They relied upon many of its principles. Its influence can be seen throughout the Constitution and the Bill of Rights: trial by jury, due process, protection against unreasonable searches and seizures, the security of private property, the preservation of the peace. These ideas did not suddenly appear in 1787. They developed over centuries. But history did not stop there. As America grew, legislatures enacted more statutes. Government expanded. Administrative agencies emerged. Administrative tribunals became common. New procedures developed. New methods of enforcement appeared. Which brings us to an important historical question. What happened to common law? Was it abolished, modified, incorporated into statutory law? Did it continue to exist alongside statutory law, or did administrative procedures gradually replace many of the remedies that ordinary people once understood and took for granted? Those are not merely academic questions. They are questions about remedies. If people once relied upon common law processes to protect their persons, property, and freedoms, what became of those remedies? Do they still exist? And if they do, in what form? If they changed, how did they change and why? Notice what we are not doing. We're not arguing that everything old was better. We're not suggesting that history should simply be recreated. We are not reaching conclusions. We're asking disciplined historical questions. Because before we can understand the remedies available today, we should understand the remedies that existed then. History often explains the present, and understanding the past frequently reveals questions that the present no longer asks. In our next discussion, we will begin examining one of those questions. If the common law emphasized remedies for injuries to persons and property, how does that compare with the administrative remedies that many Americans encounter today? That is where we continue with the next conversation. And as always, may truth reign supreme.